Afternoon, everyone, and finally welcome to the second webinar series of Chateaux Notaires in English. Chateaux Notaires, situated in Paris, decided indeed to launch a series of webinars in English for our international clients and partners that have business in France. As you know now, webinars will be dedicated to property in France, but not only. And throughout the year, further webinars will also deal with various questions of family law, business law, taxation in France and in Europe. At the end of each webinar, we should have the opportunity for live questions that each speaker could try to answer. But if we do not have enough time, you can still email us. And of course, it would be a pleasure for us to answer. Okay, so today I will introduce you a very sensitive topic about estate planning in France. As a practicing lawyer at Chevreux, I decided to choose the topic since I know from my experiences that planning a succession is a tough moment for individuals that are rather used to procrastinate with the topic. But not planning your estate often rhythms with administrative complexities coupled with a high taxation. Moreover, the ownership of international assets involves legal and tax complexities both in regard to administration and transmission of assets due to different taxation, legal, and even public policy approaches. Estate planning, what it is? It's a preventive action that intends to anticipate such legal and tax issues by allowing assets management and transmission of assets internationally with the most favorable tax treatment available, and by preventive international disputes. There are different steps, keys to understand before allowing an individual to take a decision in a matter of estate planning. Since the world is made of different legal systems and a lack of harmonization in matters of succession law, planning with international assets needs first to identify the applicable law to a future succession. That is to say, to analyze what are the conflicts of laws that are involved. Since August 17, 2015, France is now bound by the EU regulation on succession signed in 2012. The EU regulation tends to the harmonization of conflict of laws in Europe, except for the UK, Denmark, and Ireland. And therefore, the conflict of laws in matter of succession are the same in Europe now. The default law, the EU regulations provides that the law of the habitual residence of the deceased at the time of the death governs its succession as a rule, regardless of the nature and the situation of the assets. The habitual residence become now the main factor to determine the applicable law in matter of succession from the opening to the end, to the transfer of the ownership of the assets. The notion of habitual residence is thus at a central place. It determines what law and more globally what legal system would apply to a cross-border situation, but not for the tax aspect. The habitual residence should reveal a close and stable connection with the state concerned. As a result, we may suppose that personal and familial links would prevail over professional activities to determine the habitual residence. But as you know, maybe, the EU regulation enjoys a universal scope. What does that say? That is to say that the habitual residence as a connecting factor applies even if the default governing law is the law of a third state. That can be the American law or the law of England and Wales. In that situation, account must be taken of the domestic conflict of law rules of that third state, including the mechanism of renvoi, when such mechanism exists. And renvoi in legal terms, which comes from the French word, means to send back. Because of a renvoi mechanism, cross-border succession with France may involve different application law. And therefore, two different laws could be applicable to one succession. That is to say, there would be different heirs or legatees for a unique succession depending on the situation of the asset. Now you know what would be the default succession law applicable to a succession. But if you are not satisfied with it, can you change and decide for the law that would be applied to a future succession? The answer is yes. The EU regulation provides such possibility. However, one cannot choose the law of his or her choice. The chosen law is framed to the law of the nationality of the deceased at the time the choice is made or at the time of his death. As you understand, knowing the applicable law to a succession is the first main step. From this point, you will be able to plan your estate in favor of who you want and perhaps with a minimum tax to pay as soon as your choice is made, expressly made, in a declaration in the form of a disposition of property upon death. Okay, now, do you know what are the French succession law rules? Planning with French assets necessarily involves knowing the content of the French succession rules. I will not deliver all the details, but a few points here. The first point is to understand that French law, which derives from Roman law, is based on a direct and immediate transfer, where heirs directly inherit from the deceased without any judicial intervention. The French system is called universal succession. Heirs enjoy the universality of estates without the need of a personal representative or court control. However, the meaning of a personal representative is not completely foreign to French law and occurs differently with the role of the notaire. What is that? A notaire in most situations will be hired to settle succession in France. A notaire performs a dual function. A notaire can be compared to a probate and administration attorney because one of his missions is to provide legal advice to heirs and legatees throughout the succession settlement process and even at the upstream stage of estate planning. A notaire verifies whether the deceased made a will or not by querying the national wills data in order to confirm the devolution. He is an actor of the transfer of the title to new owners. He verifies the deceased property title and drafts a clear title transfer of property to make it malleable again. Okay, and the third point is about the intestate rules. The intestate rules depend on the composition of the family of the deceased. You should understand that family and children take a large place with intestate rules and succession law in general in France. Therefore, come first the descendants. This is to say the children and grandchildren in equal shares. Then, if there is no descendants, come to the succession the ascendants first, and then the siblings. There is no distinction between full blood and half-blood for the siblings. They come together. And finally come the collaterals such as uncles and cousins. And now you will tell me, okay, but what is the place of the surviving spouse in such a family tree? Surviving spouse is not a privileged heir compared to the descendants can be in France. Therefore, when a surviving spouse comes to a succession in presence of descendants, they are both going to share the deceased estate. The surviving spouse will get an option between 1/4 of the whole property of the estate or the life tenancy of it. And when the deceased has children from a previous marriage, the share is limited to 1/4 of the whole property only. The surviving spouse inherits of the entire asset when the deceased leaves no children and no parents. So here is important for the estate planning. Another point is about the specificities of French law. Apart from the intestate rules, French law knows some specificities in matter of succession law that you should absolutely definitely know when you own French properties or when you are advising when French property are involved. First of them is the forced heirship rule. What does that mean? The forced heirship is a concept by which the law rules as a public policy that a deceased cannot freely dispose of his entire estate and disinherit either her descendants. There is what we call a portion of the estate that absolutely should pass to the descendants. The portion would be 1/2 when the deceased is survived by one child, 1/3 when survived by 2 children, and 3/4 when survived by 3 children and more. The concept also means that there is at least a portion of the estate for which the deceased can freely dispose. It will be either 1/2, 1/3, and 1/4, depending on the situation, family situation, of course. As a consequence, a deceased is free to dispose of his or her assets. I mean, there is no something that can block this. However, if an individual disposes of a portion greater than that available, gifts and legacies are subject to the clawback rule, which means that these gifts can be returned or reduced to accommodate with the forced share. Now let's talk about tax. Heard of tax territoriality in France? As you know, each country has its own tax territoriality factor and rules that cover its sovereignty. France doesn't have chosen to tax a state on nationality, but rather tax on residence and the location of assets. But France is one of those countries that decide to tax the worldwide assets. Therefore, and subject, of course, to bilateral treaties that tend to eliminate double taxation, assets that are located in France, whether they are movable or immovable, and whether the deceased or its heir are French taxpayer or not, a succession should be taxed in France. Some tips about French estate tax. The estate tax is a personal tax in France and is calculated on net shares. The estate tax should be paid within the 6 months after death when it occurs in France and within the year when it occurs out of France. There are, of course, deduction and exemption. The first is the marital exemption. There is no inheritance tax to pay between spouses, nor between partners bound by a civil, French civil pact or any equivalent, foreign equivalent, for the tax purpose only. As I said, there are some deductions. The amount of such deductions depends on the quality of the person involved. A child should get a deduction of 100,000 euros if the deduction has not been used for gift tax because they are the same within the last 15 years. For instance, a brother and sister should get a deduction of 15,932 euros and a non-parent should only get a deduction of 1,540 euros. What about the rate? The tax rate for succession depends on the degree of kinship between the deceased and the heirs or legatees. In direct line, the rate varies between 5 to 45%. Between siblings, it's 35 to 45, and when you are non-parent, it's 60%. So when you are non-parent and you get 100, you have to pay 60, and you only get 40. Okay, so now you know the basic rules of succession law and estate tax in France. The purpose of the estate planning involving French assets is to organize the devolution of the assets in the way you wish and if possible with a minimum tax to pay. There is no one tool, one advice, no one solution that can be copy-pasted from one situation to another one. There are a large number of tools that can be used from French law or any foreign law unless these foreign tools are enforceable in France. Here are a sample of the main French estate planning tools. The first one I would say is make a will. We already talked about the importance that could be to elect the applicable law to a succession, and the will is definitely a device that can include such a provision. Moreover, a will is the device that is used and known in most countries. However, the form of a will is not known in the same way in all countries. For instance, France knows the holographic will, the authentic will, the mystic, and the international will, but doesn't know the dactylographic will or the joint will. Moreover, attention should be paid to the content of the will and provisions included in the will in order to make sure that one provision will not revoke another one. The second tips would be consider to buy French real estate through a French company called SCI. A French company, SCI, is a typical company that is constituted for the ownership and management of properties in France. For the ownership, the company will own the real estate and individuals will own share of the company. It allows to buy a property with different persons. As regards to succession law, shares of the company are considered being movable assets and follow the law of the domicile when the applicable law to a succession knows a succession system like the US or the UK, and no choice of applicable law has been previously made. Moreover, SCI allows for a better management of the real estate, and it avoids rules of individual and shareholders can organize management with the company statutes. Another tips point would be to consider to modify your matrimonial property regime or adopt a French marital contract. This option is for a married couple, of course, only, who want to pass the estate to the surviving spouse. Currently, France is bound by the Hague Convention of 1978 in matters of matrimonial property regime, and the convention provides the possibility for any couples to change their matrimonial property regime during marriage, and precisely to designate with respect to all or some of the immovables the law of the place where these immovables are situated. French law of matrimonial property regime can therefore be chosen when a foreign couple is intending to purchase a property in France. And among the different matrimonial property regimes, French law offers community property regime and contract provision that guarantees to the surviving spouse to get the total shares of the deceased French estate. However, please note that these rules are going to change in the next coming years, since the European Union adopted a regulation in 2016 about the applicable law related to matrimonial property regime, and this new regulation should enter into force on January 2019. Of course, we will keep you updated with these changes. A last point could be to make a gift to your children or grandchildren. Indeed, one aspect of the French estate planning is to pass of his asset to the children through a lifetime gift. The gift may be made in whole property or may be divided by a division of the ownership between the life tenancy and the bare ownership. The bare ownership is given to your children while parents keep the life tenancy of the property. But the main advantage of such a gift is that no inheritance tax has to be paid at the time of death, since the end of the life tenancy is not considered like a transfer of property, and thus there is no estate tax. We could develop more about this option and detail and calculations of life tenancy, gift tax, but the aim of today is only to provide an introduction to these estate planning tools in France. Therefore, if you wish to get much more details and combination of these rules, please feel free to contact me. To resume these minutes that go so far, on the topic, a cross-border succession involves more difficulties than a national one. That makes sense, of course, due to the different laws involved, but rather due to the interaction of the legal system. When you are faced to an international estate planning, there are some tips to keep in mind. The first one is make sure about your priorities. Find an answer to who gets what. It seems to be a quite simple thought, but the person you think to be the right heir or leaders in your country may not necessarily be the same in another country. Make sure about the applicable law to a future succession and do the right choice of law. Make sure that the given portion provided by the will provision will not be reduced through a callback system. Another tip would be, please keep updated about estate tax and non-estate and non-tax succession rules, and consult your lawyer. There is no surprise if I tell you that tax law is an area of law that is continuously challenging according to political changes. At the time of the webinar right now, France is currently leading presidential elections and two parliamentary elections. Therefore, there may be a change in tax law, even in estate tax, in the next coming weeks or years. Who knows? So just please keep updated about tax. Moreover, as soon as you have new steps in your personal life, please consult your lawyer to make sure that your past devices are still applicable. And if these strategies still are those you want to be applicable. Another point is make sure about the recognition of an estate planning device in a foreign country. Cooperation between international lawyers is a must. Again, there are more than 200 jurisdictions around the globe which means that there are such numerous and different substantive laws. None of us is able to know and to understand all of these entire rules. There's no super lawyer. Therefore, and before to opt for any strategies, check that the devices you intend to use in your home country would be recognized and foreseeable in another country. That's the first one. And second, only cooperation between international lawyers ensures that cross-border estate planning would be efficient and master other strategies, and at least for a minimum of tax to pay. Thank you for your attention. I guess we have a few minutes now, so feel free to ask questions. You can write online, and I'm going to be able to read your question, and it's going to be a pleasure for me, of course. Okay, someone is typing right now. You can always email questions. Huh? You got my email here, my phone number. So Alan is typing. Just want to make sure if there is one question. No. Okay. The question from for Alan is French property under SCI, cooperative vehicle, is it subject to U.S. inheritance taxes and not French? Not exactly. You have to make a difference between the non-tax aspect and the tax aspect. And for the non-tax aspect, if you buy a French property through a SCI company, it's going to be considered like a movable asset. Therefore, it's going to follow for the non-tax aspect, the law of the domicile, which can be a U.S. domicile. That's the first one. But for the tax aspect, because the real property, even if it's brought to SCI, the real property is located in France, and it's going to be taxed in France. There is a bilateral treaty between France and the U.S., and this case is included in the bilateral treaty. So France would continue to tax the real estate, which is located in France, even if it's included in an SCI to a French company. Are you okay? Is that okay with the answer? Do you have any more questions? Yeah, Timothy is typing right now. Tax benefits, there are some. So first of all, as regard to estate tax, it's going to be taxed in France, okay? So you're going to be subject to the French estate tax. But there is one advantage regarding the gift tax. The difference between giving SCI shares and giving a whole entire property is that when you are giving SCI shares, you are giving the net value of the shares, which can be gross value would be the real estate value, and with the deduction of the mortgage. So you're gonna give a net value which gonna be minimized, reduced compared to the entire real estate that you're gonna give. This is the main advantage. That's for gift tax purpose. For the estate tax purpose, again, it's going to depend on the value of the share of the SCI. If there is a mortgage, again, the value is going to be reduced. If you do not, if you have a real property but that is not included in a SCI company, you're going to be taxed on the gross value of the real estate, even if you do have a mortgage on it. That is the difference. So Alain, not sure question is directed of understanding tax implication of inheritance, not annual property tax. Property tax are paid by the owner, so it's not covered by estate tax. I mean, this is separate taxes. Um, so this is another topic. So I see that Timothy and Alan are still typing. Okay, thank you. That's the best thing, you know. When you have, that's what I was explaining just before. When you have an international succession, of course, you need to have a cooperation between the both lawyers, between international lawyers, first for the estate plan, but also to the for the settlement of the estate. Yeah, definitely, and you are welcome. Timothy, does France recognize the U.S. concept of valuation discounts whereby the shares of stock in a company owning real estate may not be as valuable as the direct ownership of the land? Well, I don't think so. I don't think so because it's different. We do not mix stock in a company and real estate. But I can check that question and to give you an accurate answer, of course. But I don't think so. Timothy is typing again. Well, I'm glad to have questions today. Thank you, Timothy. And of course, you are welcome for any call. So do you have any more questions? We still have, well, okay, so Cecil just told me my question was to ask you to please clarify the inheritance rules as applied to shareholders in an STI. But in answering Timothy's question, I think you answered mine. Perhaps you would like to add something directly applicable to an American shareholders with an SCI, a French company, a French property. So I'm going to try to reply to Cecil first. Okay, you would like to add something directly applicable to an American shareholders with an SCI. So when you're an American citizen holding you are a shareholder of an SCI of a French property, first, as regards to the non-tax aspect, you may be, you will be, the devolution will be follow the American law. That's the first point because it's the law of the domicile, and whether you elect the American law applicable to your French assets or not. There will be that would be the same rule. That's the first one. But as regards to tax, you will be taxed in France. So then it's going to depend on the kind of the kinship, the degree of kinship you have between the shareholders and the deceased, of course. Then, as in U.S., is estate executor responsible for very good question, for notifying creditors and forwarding notices such as death certificates? No. You have to understand that in France, we do not have executor like in the US. I can say that a notary covers this type of job, if I can say that. An executor is get a job. But it's not responsible. Heirs are responsible. As I told you, it's a direct an immediate transfer. And there is no court supervision, there is no personal representative, and there is no executor as well. But the role of the notaire is to help the heirs or the legatees to notice the creditors as an executor. I mean, a U.S. executors can do about the death, of course. But the main the responsibilities is owned by the heirs or legatees. That's the main difference with the American system and with, I would say, the common law system, which is not a direct system. Okay, so if you do not have more questions at that time, thank you for your participation, of course. You can replay this video on the website WebIKO. It's available for 7 days. And of course, you can email me when you want. My email is a.deviaux@chevreux.fr, and you got here my phone number. Thank you.